This is Michael from BioB Big Box. I'd like to welcome everybody who's joining us for tonight's presentation. Tonight we will have the pleasure of hearing from Mr. Brian Tuttle. In a nutshell, he is a HIPAA expert, everything connected to HIPAA compliance. He's really the guy to turn to. Just a little bit of background information. BioB Big Box was developed by Blue Sky Bio. Blue Sky Bio is a digital technology company operating in the medical field of dentistry. One of the products that we have is a treatment planning software that allows dentists to plan out patient treatment and creates pretty large files. One of the needs and questions that arose was how to transfer these files properly. As a result, we went ahead and developed BioB Big Box, which is a HIPAA-compliant file transfer and storage system, and could be used for such treatment plans, DICOMs, really any medical information that has personal health information, and of course needs to be transferred with the proper care and adherence to the proper HIPAA compliance rules. BioB Big Box could be used to send and receive files at no charge. There are options to upgrade to get more features, more storage, more capabilities. So we definitely recommend and encourage everybody to check out biobigbox.com and take advantage of it for your digital needs. A big part of the effort in getting BioB Big Box up and running and ensuring, of course, that all the proper measures are taken to make it HIPAA compliant is done with the cooperation of Mr. Brian Tuttle. At this point, I'd like to pass the presentation over to him to discuss practical steps that you could take in your practice to become and make sure you are HIPAA compliant. Brian?
Thanks, Michael. Again, my name is Brian Tuttle, and basically what I do is travel all over the United States doing risk analysis for covered entities as well as business associates such as BioB Big Box, making sure that folks have, for all intents and purposes, the I's dotted and T's crossed as it relates to your levels of compliance. I've been doing a lot of work lately with the various court cases because there's a lot going on with individuals suing under their state law, citing federal law. That's one of the big changes with HIPAA. In my opinion, the most dangerous change is that individuals can now be remedied for wrongful disclosures, where in the past only Uncle Sam could sue and only Uncle Sam would get paid, but that is changing now. Even though it's not under federal law, the federal government's asking states to incorporate that. In addition, I've also done work on behalf of the federal government under contract auditing covered entities and business associates, and also on the defense side working on behalf of the covered entity and business associates against the federal government. That's what I do most of my work with and what I enjoy more, because I don't believe this law is really really a fair law in my opinion. It's a little bit too gray. A doesn't equal B. There's too much subjective information here, and it's all based upon risk. So the bottom line, and I'm going to say this a lot through this presentation, is you've got to be proactive, not reactive. Proactive meaning get those risk assessments done. That's the #1 area of noncompliance, and the first thing that the Office of Civil Rights will ask you is, where is that risk assessment? Get that done. Make sure you have policies in place, staff's adequately trained, and so on and so forth. We'll get into the details here, but make sure that's done before you get the letter from the Office of Civil Rights that you're going to be HIPAA audited. Because there's one thing for sure, if you're not proactive and you're reactive, they will throw the book at you. The key here is to be proactive. And so with that said, I will go ahead and begin here. A little bit of history. I'm not going to spend much time on this at all. We all know what HIPAA is. It's the Health Insurance Portability Act of '96, enacted by U.S. Congress and signed by Clinton in the same year. And it's interesting, but in the acronym, there's no mention of the word privacy or security. So it's also called the Kennedy-Kassenbaum Act, named after its two sponsors, Ted Kennedy and Nancy Kassenbaum of Kansas, one a Democrat, one a Republican, so we can blame both parties for this. As I stated a second ago, privacy, security, not even in the name HIPAA, the acronym is Health Insurance Portability and Accountability Act. But privacy and security are our biggest challenge as covered entities, being dental groups, medical groups, insurance companies, plans, clearinghouses. Those are all covered entities. They must comply with HIPAA. And also business associates must comply with HIPAA. So the privacy and security aspects of this are the biggest challenges to those groups. So moving forward, there are 5 titles to HIPAA. This isn't that important to understand, but what is important to understand is under Title II, Administrative Simplification, that's where we find privacy and security, along with coding, meaning the ICD codes and so on and so forth, which present our biggest challenge. The biggest challenge is under this one little subset of Title II. That's where we find privacy and security. Because when most people think of HIPAA, you think of be quiet, don't disclose private health information, don't email private health information, make sure it's secured, so on and so forth. That's what most people think of HIPAA, but there's a lot more to it than just privacy and security. But privacy and security is the biggest challenge. We all remember the fable, The Boy Who Cried Wolf, and that's what this law is to me. Doing this for 17 years, when this first came out in 2003, the HIPAA security rule anyway, yeah, the government put in regulations and laws, but they didn't enforce it. So what good is a law if it's not enforced? They would say, do this, do this, do this, do this, or else. Well, there was never an or else. So people just didn't take it seriously and kind of let it go, sweep it under the rug. There's so many other things going on in your practice. The last thing you're really concerned with is HIPAA, to be honest. But unfortunately, times have changed, and especially as of September 23rd, 2013, when the HIPAA Omnibus Rule went into effect, this is real. And I can tell you from personal experience in doing compliance consulting all these years, HIPAA was always on the back burner. It was typically OSHA and other areas of compliance that medical practices deal with, the CMS, coding, things like that. But not anymore. This is on the forefront. I'm getting calls and emails every single day from groups all over the country saying, oh no, what do we do? What do we do? We got a letter from the Office of Civil Rights saying we're getting audited for HIPAA. What can we do? So this never much occurred in the past. And also folks getting sued, which I'll talk about a little bit more later, which I talked earlier about the ability individuals can get remedied under state law citing federal HIPAA. So the wolf has indeed arrived, and there he is. And I know this is all, fun and games here, the little pictures, but this is true. The wolf is here. This is not something we need to sweep under the rug anymore. Be proactive. An ounce of prevention is definitely worth a pound of cure with this law more than any others. So I like to think of HIPAA as this little poodle prior to September 23rd, 2013, which is when the omnibus rule went into effect. Yeah, it had teeth, it had a loud yap, a loud bark, but couldn't really do anything. But now, after September 23rd, 2013, it's more like the honey badger. You can't kick one of these off your leg. This is here, it's here to stay. And one of the reasons the government's so hell-bent on the enforcement now is because we are moving to a electronic world in terms of healthcare. All of these electronic health record systems within medical practices, dental offices, so on and so forth, eventually will all be communicating with each other into the health information exchange up in the mysterious cloud. The cloud just means off-site data centers, really. So there needed to be in place more security, because healthcare, dental, whatever it is, historically has been terrible at securing private health information, securing sensitive information. And if you think about it, you've got access to names, addresses, health records, social security numbers, and all kinds of information here in that health record. And the 18-year-old scheduler at your practice, what kind of background checks have they gone through? What kind of scrutiny have they gone through to have privy to all kinds of information? Whereas the person, the teller at the bank, goes through enormous amounts of background checks before they get access to this. So those are little different ways of looking at this, but that's what's being brought into here. It's going to be your hiring procedures, your termination procedures, your physical security, your organizational security, your technical security, getting into the encryption and all of the geek speak as we move forward. So there needed to be more in place with healthcare. The problem is the way the government enforces this is just kind of wonky. It's not clear. They tell you what to do, but not how to do it. Hence why it's very important to get that risk analysis done prior to them getting there. One thing about that, you're almost better off, in a way, if you've got worse security of the private health information, but you have done your risk analysis and you have policies and you train staff, than you are if you have fantastic security in place, but you've never done the HIPAA risk analysis and put policies in place and so on and so forth. Because when audited, the government likes to see that you're making due diligence and effort towards this, just as much as they like to see the actual real security itself. It defies logic and reason, but we are dealing with the federal government here. And again, I'm going to keep saying this, proactive, not reactive. All right, so moving forward, September 23rd, 2013 was D-Day in the HIPAA world. That's when this omnibus rule went into effect. And what it did is it increased penalties. It equals the burden between business associates and covered entities. And primarily for covered entities, it enforces what was already on the books. It also greatly enforces and increases federal auditing. And even more importantly, it gives individuals, or it encourages states to set laws that give individuals the right of remedy for wrongful violations of their private health information, when in the past only the government would get paid. So just a little bit of review. HIPAA has historically been a relatively benign law, no consequences for actions in most cases. You may occasionally hear of an audit occurring. It's been more of a nuisance than a real problem. Fines were low and rare. Audits were low and very rare, unless, again, there was a massive breach somewhere. You very rarely heard of these things occurring, and only the government could sue in the past. So can you and me be arrested for wrongful disclosure of PHI, private health information, or protected health information, whatever you want to call it? Yes, we can. And make sure you constantly reinforce this to your staff to let them know they have a personal interest in making sure that PHI is secure. Because if they go home and go on Facebook and wrongfully disclose private health information, or they verbally disclose private health information out at the local McDonald's and other people overhear this, they can individually be arrested technically for this if it's malicious enough, but definitely fined. But to protect your practice, you need to make sure that your staff are aware of that they are trained to understand, do not do this, that they sign off on confidentiality agreements that say, I understand that if I wrongfully disclose private health information, it's on me, not the practice. I can be terminated, and I can also be civilly and criminally charged for this. Very important, because if you don't train your staff, a staff member does go rogue and does something wrong, yeah, they're going to get in trouble, but guess what? Any attorney worth their salt is going to come after the practice, because the individual's a hundredaire and the practice is, insurance company anyways, millionaire. So it's important to protect your practice by training your staff and having them sign off on these things. And I've sat in a lot of court cases where this is going on, that staff member says, oh, I just didn't know. Well, you need to make sure they do understand. Can the practice or the business be fined for HIPAA violations even if a breach does not occur? Yes, that's another big change with the omnibus rule. In the past, you could only be fined if a breach actually occurred and the government could prove that it occurred due to willful neglect, but not anymore. If you're audited and you don't have mechanisms in place to prevent a future breach, you can get fined, such as not having risk analysis done, not having policies in place, not training staff, not auditing systems, not having an adequate disaster recovery plan, so on and so forth. All of the HIPAA implementation specifications need to be addressed, need to be in place via policy, or you can technically be fined. You can be fined for physical situations. If you live in if your practice is in a high crime area, your server's next to a glass window, next to a wooded area, which you've had break-ins before, you don't have an alarm system, you could be fined for that because that's a very high risk. If you don't have a window at check-in, your staff speaks very loud, there's no TV playing, anybody in the lobby can overhear all kinds of information because your staff is violating the minimum necessary standard and speaking more than they need to, and you can technically be fined for that. So make sure to get that risk assessment done and find out where those problems are to mitigate that proactively. Business associates. I know most of you guys are not business associates, but it's important to know who they are. These are individuals or entities who create, receive, maintain, or store PHI on behalf of a covered entity. They can be, like I said a minute ago, even individuals. A 1099 individual would be a business associate if they're privy to this information. Answering services, medical transcription, IT companies, billing companies, shredding companies, collection agencies. These are all clearly under the auspices of business associates. Penalties are much worse now. $50,000 per violation to a maximum of $1.5 million for repeats of the same violation. And I have seen the $1.5 million fine dealt out on occasion, and typically it's for just wanton neglect, quite frankly. Really, really bad IT is what got the ones I'm speaking of pinched here. Fortunately, these got mitigated down through arguing with the government, but nonetheless, they will hand these out if they can prove there's basic, not just willful, but just basic neglect, that you've got very old systems in place. You're emailing unencrypted information all day long, back and forth to your billing company, back and forth to your transcription company, and nothing's been done all these years. They'll throw the book at you. And there's also criminal provisions applicable to individuals as well as the covered entity and the business associate. So what constitutes a breach? This is the million-dollar question, but you should have in your practice a breach incident investigation form. Basically, this form just is you can download this from hhs.gov. It's important that if a suspected breach occurs, you fill out this form. Even if your findings conclude that it was not a breach, you still want to have these forms in place, and you want to document and save these forms somewhere, because if you're ever audited, an auditor would, it actually looks better that you have had suspected breaches in the past, or maybe even real breaches, because if you've been in business for 20 years and you're a relatively large organization and there's never ever been anything, that seems a little bit weird to an auditor. But with that said, covered entities and business associates have to demonstrate there is a low probability that the private health information has been compromised, and the burden is on the covered entity or business associate to prove that notifications were provided or that a breach did not occur. You also need to take in consideration the nature and extent of the private health information involved, including the types of identifiers, the unauthorized person who used a PHI or to whom the disclosure was made, whether the PHI was actually acquired or viewed, and the extent to which the risk has been mitigated. And again, hhs.gov, Health and Human Services.gov, if you type in breach incident investigation form, you can find a basic template. That's all it is a basic template. But if you ever suspect something, you need to fill that out. For example, if you lost a laptop that contained private health information, you need to fill out this form. Okay, but if the laptop were encrypted and you lost it, you still need to fill out the form, But at the end of the form, you would state, there has not been a breach because the laptop was encrypted. That's one example. Another example, you snail mail a letter to the wrong address, and the person who received the letter is nice enough to send it back, or it was just a return to sender. You probably want to fill this out, but you can conclude again that no private health information was wrongfully disclosed based upon reasonable and appropriate considerations here, because the letter was returned still sealed in the envelope. That's basically how this letter is sort of like a flow chart, or the form, I should say. Okay, a little bit of information here from the director of the Office of Civil Rights, a gentleman named Leon Rodriguez. And I know a lot of you are dental groups, but if you are medical and you took money for implementation of electronic health records, the odds of you being audited for HIPAA, it's not really if, but when. And this is a quote. With the revenue being brought in from the audit process, the federal government hopes to recoup losses for meaningful use Medicaid and Medicare payouts, because the government will pay you money to implement electronic health record system. Once you do that, they will audit you, trying to take the money back if you're not using it in a meaningful way. He also quotes, I expect we are going to see large monetary settlements for a long time to come. Just a little disconcerting there. So bottom line, and then we'll move on to some more relevant information of low-hanging fruit here, everyday things. But the government plans to make the audit process a money-making venture to bring in revenue. Outsourced firms and individuals such as myself working on contract with the government have a vested interest in levying fines. You would think, because if the firm is getting a government contract, they would have a conflict of interest somewhat to find things wrong, or they're going to lose the contract with the government. So it's a catch-22 and just a messy system. So real quickly, omnibus and suing. I'm not going to spend much time on this, but just to be clear, an individual cannot sue under federal HIPAA. There's no private cause of action allowed to an individual to sue for a violation of the federal HIPAA or any of its regulations. This means you, the patient, do not have a right to sue based on a violation of HIPAA by itself. What most people don't get about HIPAA is that as extensive as the statute is, and as serious as its potential penalties are, Congress, in its infinite wisdom, chose not to include a private right of action. But you, the patient, may have a right to sue based on state laws, and as of the omnibus rule, the federal government is encouraging this of the states. The omnibus modifications to HIPAA in 2013 made no impact on an individual's right of action under federal HIPAA, but they do affect individuals in tangential ways, because omnibus grants, whatever state you're in, the Attorney General the ability to bring civil action and seek damages on behalf of their residents for HIPAA violations. So real quickly, how does this occur? The first thing an individual is going to do when suing your practice is, and they're going to be instructed by their attorney, first thing, file a complaint with Health and Human Services for a HIPAA violation. Health and Human Services says, yes, this is indeed a HIPAA violation, and they will always investigate. So Health and Human Services, if it was a HIPAA violation, is going to fine your practice. You're going to get it from that side. Then the individual is going to go to the state's Department of Health and file a complaint against the physician, dentist, nurse, whoever it was. Then the individual is going to go to the payer, whether it be insurance, it could be Medicare, Medicaid, TRICARE, Champus, VA. They're going to go to the payer, and they're going to file a complaint there. So then you're going to have the payer on your back. And if it's Medicaid, it can go into the peer review system Medicaid has. Then they're going to go to if they have an insurance company, if it was an insurance company, they'll go to the insurance company and file a member grievance so the insurance company can come after you. Then they're going to move from there into their relative state law and get remedied through their state law to get paid back. So these are the methods in which they're going to go through this. There's a whole lot more to this. I don't have time to get into all of the nuts and bolts of the litigation process here, but I really wanted to throw that out. This is new. To me, this is the most dangerous aspect of this whole piece here, is individuals learning this. Because unfortunately, we're a litigious society, as you know. So let's move to the HIPAA security rule. This is the #1 area of non-compliance with HIPAA, is the HIPAA security rule. What is the security rule? It's the standards for the protection of electronic protected health information. It ensures that business processes and technologies used are not vulnerable to threats. There are 18 standards and 44 implementation specifications of the HIPAA security rule. Just because it says security and it's electronic, don't think it's all electronic, because we're dealing with administrative safeguards, meaning who are you hiring? Are you doing risk analysis? Are you doing disaster recovery? Are you auditing systems? Then the physical security. Where are the systems kept? Are they physically secured? Do you have alarm systems? Are you destroying data prior to discarding? And then we get into the technical safeguards. So I'm going to quickly go through all 44 of these, and I can't spend too much time on each one due to time constraints. But before I jump into that, the administrative safeguards. This is the first. It's broken down into administrative. Let me jump back. Administrative, physical, technical. Here at the bottom, administrative, physical, technical. Each of these have 18. Well, there's 18 standards total under all of these, and 44 individual little implementation specifications. The first one, under administrative safeguard, the standard security management process, the implementation specification, is risk analysis. It is required. Some of these are required, some of these are only addressable. This one's required. It says conduct an accurate and thorough assessment of the potential risks and vulnerabilities to the confidentiality, integrity, and availability of electronic protected health information held by the covered entity. Basically states you must do a risk analysis. That's where you identify all the problems. That's the core of everything. Do the risk analysis, find where the problems are, put it into policy. And then next slide, this is the same thing, risk analysis. Determine the various sources of electronic protected health information, how it flows through the practice, and the human, natural, and environmental threats to that electronic private health information in each area. The risk matrix should evaluate the risks given consideration to measures already in place. A more thorough analysis should be done through your IT resource. Now, when doing a risk analysis, it should also be done not just for electronic, but also for paper-based PHI, because there's still a lot of folks using paper-based PHI, and that's just as big a risk, if not more, than the electronic PHI. Risk management. These two sort of work together, that we're still under administrative safeguards. Implement measures sufficient to reduce the risks and vulnerabilities to a reasonable and appropriate level. Reasonable and appropriate, those two words are used all through the legislation. Let me be clear, with a covered entity dealing with all kinds of verbal disclosures, paper disclosures, so on and so forth, there is no such thing as 100% compliance. It's all based on taking reasonable and appropriate due diligence to limit risk. That's all the government asks. There is no perfection here. It's all about reasonable and appropriate due diligence. Evaluate the security measures already in place, involvement of management, communication of security processes within the organization, and necessity to utilize other resources such as an IT specialist. The HIPAA Omnibus Manual includes policies and procedures for security rule compliance. That's part of my manual. That really doesn't apply to this particular piece here, but nonetheless, risk management, risk assessment, basically the same thing. Sanction policy. You need to have sanctions in place against workforce members who fail to comply with your policies and procedures of the practice. Meaning staff need to be trained, they need to sign off on some sort of confidentiality agreement saying that if they do access records they should not be accessing. They need to be penalized for that. If they're sharing passwords, they need to be penalized for that. Sanctions for failure to comply with the practice's HIPAA security measures must be across the board, not limited to one level. It must include the providers, managers, supervisors, and other workers. Penalties should be based on the severity of the violation. And providers, don't forget, providers, they're some of the biggest violators of HIPAA here, and I've got many, many, many examples, which I don't have time to get into, of providers costing the practice thousands and thousands of dollars due to violations from just not taking this seriously. Information system activity review. This is required. You must regularly review records of information systems to ensure that access is appropriate. Basically, making sure that user Brian isn't logging into his mother-in-law's chart if I have no business going in there. You should fine me, or not fine me, but sanction me for doing so, or fire me, or whatever you're going to do, because I have violated her civil rights if I went into someone's chart that I don't have a medical reason in going into. That's a big deal, very important. Audit those systems, understand what that is, and understand how to do it, because if you're audited, the auditor will ask you to do that and show them how it's done. This is also to ensure someone in the practice is monitoring the systems for unauthorized access by unauthorized individual straying from the area authorized, and an authorized individual staying in that area longer than necessary to do the job. If you have a lot of VIPs come into your practice, meaning famous people or things that may trigger some sort of interest, you probably want to audit those systems and make sure people aren't snooping around where they should not be. Because if a patient were to sue, they can get that information through discovery and find out what's been accessed, and technically that can work against you. If this information should be captured by the computer system, however, a human being, of course, must review these reports and take actions. Corrective actions depend on the problems found. The practice may need assistance from your IT specialist or the vendor of the system, or may need to discipline the individual. So whatever is found and whatever is done must be documented. So if you are doing an auditing of your system, I recommend, very simple, takes 5 minutes, a simple Excel spreadsheet of who performed the audit, what was audited, when the audit occurred. Very simple. Do it monthly. Doesn't take that long. Make sure staff all understand as well that Big Brother is watching. Your footsteps are being monitored. Authorization supervision. Implement policies and procedures to ensure that all workforce members have appropriate access to the information and to prevent those workforce members who do not have access from obtaining it. That's addressable. So you want to provide access to all of your staff only based on roles. So no staff member should have more access than they need. The reason this isn't required is sometimes all staff members need complete total access to the system. However, you need to justify why you're doing that. Perhaps if you're a very tiny practice with 3 total staff members, the father's the doctor, the mother's the practice manager, and the daughter's the scheduler, well, yeah, they all need complete access, so that's justifiable. But when you're a very large group, you're going to have a very hard time justifying that. Workforce clearance. This basically means, who are you giving access to this information? Are you doing background checks? Are you checking references? Do not ever give anybody access to private health information and all this sensitive information unless they have been vetted, background checks, something to make sure this person who's getting access is a good person. Because if you allow, let's say you hire me and you give me access to all these health records and social security numbers, well, I've got 5 or 6 theft convictions in my past. You don't run a background check on me. I do something bad, steal identities, compromise health information, all kinds of things that could be done. Yeah, I'm going to jail, but in the process, those individuals, they're not going to sue me. I don't have any money. They're going to come after you. And if you don't have a defense of saying, well, you didn't do, the prosecuting attorney is going to say you didn't do background checks, you didn't vet these people, then you're going to have a problem. So very important. Anybody privy to PHI needs to be properly vetted. You need to also terminate adequately. Make sure you have a termination checklist in place, that individuals are adequately being removed from the system. You should also do an exit interview, letting all individuals know, even when you leave this practice, you guys are still responsible for that information in your head. So if you fire me, I still cannot wrongfully disclose anything I've ever learned while at your practice, or I am legally responsible. Very important to remind them of that. Isolating clearinghouse functions. This really doesn't apply that much anymore. Usually your billing system or EHR or whatever you're doing your billing with has a business associate agreement in place with the clearinghouse that you use. If not, make sure you have some kind of business associate agreement in place with the clearinghouse, because the clearinghouse in of itself is a covered entity. This is very low risk. I don't even really know why it's still part of this. It's a very old implementation specification, not too much of a concern anymore. Access authorization. Implement policies and procedures for granting access to private health information, for example, through a workstation, transaction, program, process, or other mechanism. Authorization is defined within this rule as the act of determining whether a particular user has the right, based on job function or responsibilities, to carry out a certain activity, such as reading a file or running a program. Again, very close to access establishment modification as earlier. You want to make sure staff have the adequate amount of access to perform job function, not too little, not too much, and have a policy for that. Access establishment modification. If a job role is modified, then you need to modify access accordingly. Very simple. That means you just increase their rights or decrease their rights, depending on what the case may be. If a scheduler got their LPN license, now they're a nurse, then yeah, they may need more access to perform job functions. So you need to do that. Very easy. Security reminders. This is basically training, security awareness and training. Are you training your staff? I know this says addressable, but I've never seen a situation where a staff who was not training, or a group that was not training their staff, that was acceptable. You need to train your staff upon hire, and you also need to train on an annual basis, and you need to make sure that they sign off that HIPAA training was received. Very, very, very important, because in every single audit letter from the Office of Civil Rights I've seen, they're asking to see training records. So make sure and do that. It's very easy. It can be done web-based. You can outsource it. You can do it in-house, however you want to do it. Protection from malicious software. This is probably one of the most applicable parts of the security rule, as we're really getting into technology here. Procedures for guarding against detecting and reporting malicious software. Basically, do you have adequate antivirus? Do you have adequate firewalls on your practice? Make sure you're not using some cheap Walmart Linksys firewall to secure your practice, especially if there's a server behind that. Make sure it's an adequate enterprise level firewall. Make sure that your antivirus is enterprise level and you're not using free versions of the Windows antivirus, especially if you're transmitting, accessing, or storing private health information on that machine. It needs to be enterprise level. Let IT experts handle this, because most practices don't, in practice managers, doctors, so on and so forth, don't always understand IT. Make sure experts are doing this, and don't always trust your IT either. Make them prove to you what they're doing is in fact what they're doing. Login monitoring. Does your system have the ability, do you have the ability to tell who's logging in? Can you monitor login attempts? Does the system kick out after so many failed attempts? If not, why? You should make sure your systems kick out after so many failed attempts, and also can monitor and ascertain who is logged into the system at that time. Any competent system can do that, but make sure you understand how that's done, and there's a policy in place for that. And again, this may be some input from IT. Password management. Always need to have passwords for any systems accessing, transmitting, or storing PHI. Passwords should, as a rule, be at least 8-character complex and changed every at least 180 days. That's just the rule of thumb. But HIPAA does not specifically state one way or the other, but the rule of thumb, 8-character complex changed every 180 days. Response and reporting. Do you have something in place where you can identify and respond to suspected or known security incidents and mitigate to the extent practicable harmful effects of security incidents that are known to the covered entity and document the outcomes? Basically, this is pretty simple. It means if an incident occurs, what are you going to do? You're probably going to notify your IT, but you need to document these things. And IT may document a lot of this as well if you use some sort of outsourced consultants here. Not that difficult, but make sure a policy is in place for this. By the way, a policy needs to be in place for every single one of these that I'm reading. Data backup plan. What's your data backup plan? Do you store data off-site, on-site? When you store off-site, is it encrypted like Big Box Bio has ability to store data off-site in an encrypted manner? Do you have data on-site as well? I recommend doing both. Have it off-site, have it on-site. That way, you have it on-site, it's quicker to get the data back if something occurs. You have it off-site for a disaster recovery situation. Which brings me to the fact of, do you have a written disaster recovery plan? This is required because it is a patient's civil right to have access to their private health information. So you, as a covered entity, must provide that access in a reasonable time frame. If you had a major disaster, let's just say your building burned down or a tornado hit it or the server got flooded or something, your only backup is in that server room on a thumb drive. Well, guess what? That thumb drive is going to go up in the flame or go in the twister. So you need to have something off-site as well and a written plan on how you're going to get that data back as quickly as possible. How are you going to operate under emergency mode? This typically is not a big problem because for most entities, you're going to operate the same way regardless in emergency mode or not as it relates to security of private health information. Testing and revision. Have you ever tested your contingency plan or at least tested your backups? You definitely want to test backups from time to time. And don't trust IT when they say backups are good. Make them prove it from time to time. Say, well, I want you to prove to me my backups are good, because if I had a nickel for every time IT folks say backups are good and they're not good and a practice is facing doomsday, I would have about $2.45. And my background is heavy in IT, so I just I'm very peculiar on this and making sure those backups are good. Very important, not just for HIPAA, but just for your business in general. Application and data criticality analysis. This is simple. What's the most important things you need to have back up in order? Number one, the computer system. Number two, I guess the phone system, so on and so forth. That's very easy. That's all part of a contingency plan. And there are contingency plan templates available out there. I can certainly provide those as well as it relates to HIPAA as part of a risk assessment that puts all this together fairly easy. Evaluation. This is very similar to risk analysis, but are you evaluating your IT infrastructure periodically? Are you making sure to do penetration tests, basically emulating a hacker trying to get in from the outside to ensure things are secure? Are you doing non-technical evaluations throughout the practice of your physical security and so on and so forth? This basically parrots risk analysis, which we spoke of earlier. One thing you'll notice about a lot of these HIPAA implementation specifications, a lot of them are redundant. So there's a lot of redundancy, or at least semi-overlap. Business associate agreements. Do you have a written business associate agreement in place? Is it signed off by all of your business associates that you guys use? Make sure it's up to date for 2013. If it is not up to date, it needs to be updated and signed off. And make sure you have that. If you don't have a new one, you can get one from hhs.gov. They have the most updated versions of business associate agreements. Contingency operations. Basically, who needs to have access to the facility in the event of a disaster? Not a big deal, pretty clearly known. Facility security plan. How are you securing the actual facility itself? Do you have physical security measures in place? Who are you letting into the facility? How are you controlling that? Are you making sure folks who come in sign the business associate agreement, are only given the amount of access necessary, or escorted back so no one can just walk into the practice? That's not typically a problem anymore, but nonetheless, things to consider. Maintenance records, very low risk, but do you maintain records of changes to hardware, walls, doors, and locks? Not really a big deal unless you're a gigantic hospital with hundreds of doors and locks everywhere. Yeah, you may want to maintain records, and most folks do maintain these records anyway, just for tax purposes, to write them off. Workstation use. Do you have a workstation use policy? Usually this is part of the employee handbook, proper use of workstations. Disposal. How are you disposing of paper? How are you disposing of data? Make sure it is destroyed. Paper being shredded, data being destroyed as well. Very important. Never throw away a computer server, thumb drive, anything that contain PHI unless that hard drive is destroyed. If you're reusing computers which once contained PHI, you should wipe those first, re-image them with a operating system, and then hand them to the next user. That's just a best IT practice in general. Accountability. Where are the systems? Do you keep a record of systems within the business or practice? Are you signing out laptops? Typically not a big risk for small groups. You typically know exactly where machines are at all times. Data backup and storage. Do you have a record of the movement of hardware and electronic media and any person responsible? Actually, that's redundant from the last one. I apologize. Data backup and storage just basically means, do you have a backup of data in the event that you are physically moving the server? And nowadays, you're always going to have a backup, at least a local one, when physically moving the server. Unique user ID. Assign a unique username to an individual accessing systems. Very simple. Emergency access procedures. How are you going to get access into the systems under an emergency situation? Typically, direct login to the server is something that's done. Automatic log off. You should have machines log off after no more than, as a rule of thumb, 15 minutes of idle time. That all depends on where the system is, how much traffic it's seeing, but you should always have staff manually log off when they leave their workstation. Have a policy for that. Encryption and decryption. Mechanisms to encrypt and decrypt private health information. What are you doing to encrypt and decrypt? Audit controls. Again, very redundant from what we spoke of earlier. Are you auditing systems and making sure user action is appropriate? Almost any system has this ability. Make sure and understand what that is so you can know what users are doing within the systems. Integrity. What are you doing to assist the integrity of the data? Are you encrypting your transmissions? Never email non-encrypted private health information. You can use a company like Big Box Bio to make sure emails are transmitted securely, data is stored securely. Make sure you're training staff prior to entering live data, because you can certainly get issues there. Make sure you're implementing the minimum necessary standard when accessing systems, and system auditing. Those all go into integrity. Mechanisms to authenticate electronic private health information. See, a lot of these, again, very redundant. Implement electronic controls to corroborate that electronic protected health information has not been altered or destroyed in an unauthorized manner. Well, how would we know that? Well, through our auditing, through checksums when backups are done, and through encryption. Basically, those are ways to authenticate that information has not been altered or destroyed. In person or entity authentication, basically, how are you authenticating? Well, in most cases, it's just a simple username and password. Maybe some places use biometrics and some other higher end things, but basically username and password, very simple. Integrity controls as it relates to transmission. What are you doing to ensure integrity of data via transmission? Well, you're going to be using encryption via transmission. That's how you're going to ensure integrity of data. Encryption via transmission. How are you actually doing the encryption? What are you using to encrypt that data? Wireless, is it encrypted? Emails, are they encrypted? If you're taking thumb drives off site, are they encrypted? Very, very important. And another thing, never bring a thumb drive back into your practice that you find in the parking lot. That's how a lot of viruses get spread these days, with a trick that hackers use. So, factors that can cause major HIPAA headaches: your internal staff, your patients, if you took meaningful use dollars, your business associates, previous or current breach, not reporting a breach, and a disaster. Let's talk about each one of these. Your internal staff. Your internal staff members may be disgruntled, not well trained, loose lips, social networking, careless. Your internal staff is your number one risk. Number one risk. You've got to make sure and hire good people, because they are your highest risk with any business from any kind of security. What can you do to mitigate risks with your internal staff? Educate, explain personal responsibility aspects of HIPAA. Always report a breach if it happens. If a breach happens and it is not reported, that is a $150,000 fine. You may wonder, well, how would we ever get caught if a breach occurred? I mean, we just brush it under the rug. Well, I'll tell you how you get caught. A disgruntled staff member turns you in. That's how you get caught. I've seen this multiple times. Sanction staff for wrongful disclosures, and audit your systems for making sure staff's doing what they should be doing. In the first wave of audits, in terms of what happened with the federal government, number one area of non-compliance, risk analysis. Number two, lack of written policies. Number three, lack of staff training. Number four, lack of a contingency plan. Number five, lack of proper auditing. Number six, not having breach notification. And number seven, weak IT support. I added that because I've seen that a lot. What can you do also to mitigate risks continued with internal staff? Workforce clearance procedures. Make sure you hire good people. We talked about that earlier. Make sure you terminate good, which is an oxymoron, but make sure terminations are smooth if possible. Make sure you train staff. Remember, security, awareness, and training. We talked about this earlier through all of that long list. Make sure that staff understands they are personally responsible for this. Discuss something about security in every meeting, maybe email reminders, sticky notes, so on and so forth. Let's move to patients. How can patients cause you an enormous nightmare? They may be upset with a bill, bad customer service, poor bedside manner. Patient sees their chart laying around where anyone can see. Patient overhears too much information via careless verbal discussions. How can you mitigate risks with your patients? Bottom line is, with any business, good customer service, and make sure and reinforce this to staff. Patients who love their doctor and staff are less likely to cause an issue, even if some areas are lax. That's just common human nature. Train staff also to only verbally speak the minimum amount of information necessary to perform the job. This is also called the minimum necessary standard, and it's used all through HIPAA. Set up practice physically in a strategic manner. And of course, this is a greater risk as patients now are learning they can get remedied for wrongful disclosures under state law citing HIPAA. Next slide. Never leave a voicemail for any patient which discloses PHI. Never disclose information to any family member unless they are on the authorization form. Auditors, I've never seen this occur, but the government said auditors may call and pretend to trick staff into a HIPAA violation. I think you as management should call and try to trick your own staff into HIPAA violations. So call knowing you're asking for information they're not supposed to give you. If the staff member does not give you the information, give them a $10 Walmart gift card perhaps to reinforce the good behavior. If they don't and they violate HIPAA, then sanction them. That's just a thing I think would work very well based upon your risk. Keep voices low when discussing private health information throughout the practice. Limit discussions within the practice to the minimum necessary. Close windows at front desk as much as possible and keep conversations to a minimum. Close doors to exam or treatment rooms before discussing the PHI. This isn't always applicable to dental offices, I get that, but where applicable. Discuss financial issues in a private area, because nothing would make a patient madder than their financial issues being discussed in front of other patients, like they can't pay their bill, for example. Limit traffic in the clinical areas. Escort individuals who are not part of the workforce while they are in the clinical areas. Position terminals and written PHI so that unauthorized individuals may not readily access it. Place any papers and chart holders in such a manner as to protect any patient identifiers or health information from unauthorized individuals. This may mean placing the papers in the holders backwards, using only opaque holders, or using opaque paper in front of the health information. And of course, cover schedules or place them where unauthorized individuals cannot see them. And patients may not outwardly say they are upset, but they may be, because you just don't ever know with people. Meaningful use. If money was taken from the government to adopt electronic health records, your risk is increased because, remember, the OCR director said, with the audit process, we hope to recoup monies lost via meaningful use payouts. What can you do to limit risk? Nothing. There's nothing you can do if you took that money. However, if you have implemented electronic health records and you've done it the right way, normally, and this is based upon my experience with hundreds and hundreds of clients, that if you've implemented it the right way, you have actually a higher level of compliance, at least in the IT area, by the very design of these things. I won't spend a whole lot of time on there. I know most of you guys are dental. Your business associates, they can present you an enormous amount of risk. Perhaps they're disgruntled. They think they should have been paid more, and they could turn you in. Perhaps you notice they're doing things in a non-compliant manner. You need to put an end to that, or you guys can get fined, even though it was them that caused the breach. You both would get fined. Ousted IT companies. I hate to pick on IT folks, but be very careful if you're switching IT companies to do due diligence here, because IT folks know where all the bodies are and know all the back doors in. Your business associate may not protect your PHI adequately. Maybe they're ignorant of their responsibility. And even though a breach of your practice's PHI, if it occurs by the business, albeit the fines would be levied against the business associate, it can certainly spurn an audit against your practice, if not fines, assuming you guys may have known about it, then that can cause fines. But at the very least, it puts egg on the face of your practice, because you have to notify your patients what occurred by your business associate. So how do you limit risks? Know what their policies are. Make sure your business associates, like Big Box Bio, are HIPAA compliant. Make sure they are. Ask for reassurances. If they're not, don't do business with them. Educate them. Let them know they are entirely responsible under HIPAA for your private health information or your businesses or your practices. Ask questions. Always make sure a business associate agreement is in place as well. Not reporting a breach is certainly a big, big risk. As we discussed earlier, you are required to report a breach if it occurs. If you do not report a breach, that is a $150,000 fine if found out, and it is a disgruntled staff member that normally gets you caught here. How to mitigate risks of a breach? Well, this is what basically HIPAA is all about, at least HIPAA privacy security. Conduct your risk assessment, put proper policies in place, train staff, have good business associates, good IT practices, always abide by the minimum necessary standard, and audit your systems. More risks for a breach. Data transmissions via email. How are you emailing? Is it encrypted? Make sure emails that you send are encrypted. Make sure you're using a good encryption system. Do not ever send PHI in unsecure methods. Thumb drives. Never take a thumb drive off-site unless encrypted. Never ever bring a thumb drive into your practice that you may have found. Never do that. Never plug that in. Like I said earlier, that's a little sneaky way folks are getting into systems now. In fact, they'll even put your logo on there and try to get in on the thumb drive, especially for bigger groups. Smartphones. Always password protect these things. There's a lot of risks here. Never text PHI. If you're going to text, make sure that's secured. And if your email is on the phone or anything's on the phone, make sure it's kept securely on that phone. And again, I said it a second ago, always, always password protect those, period, regardless of HIPAA. That's just common sense. You've got a lot of private information on there above and beyond HIPAA. Don't ever share passwords. This is a HIPAA violation. If I know your password, I can log in the system and I can wreak havoc with your account, thus leaving you liable. Never, ever share passwords, and you don't even want to know what your staff members' passwords are, even if you're the manager, because if you know my password, I can still do things under my name and say, well, you knew my password, so you did it. You don't even want to know anyone's passwords. All passwords should be known only to the user. You can wipe the passwords from the administrative console if needed. Never throw away. Just remember we talked about disposal. Hackers love trash. Always wipe or destroy before throwing away private health information or data or hard drives which could have contained PHI. Social networking. Lots of high risk factors here. You should have a social networking policy in place that staff understand not to be going on Facebook, even on their own time, ever discussing information of the practice. And I would recommend trolling your staff members' Facebook pages to make sure they're not doing that. Too many admin passwords. You don't want to have that. You want to make sure there's only one admin, maybe two, which means full super user access to the system, because that would be violating multiple areas of HIPAA if you have everyone as an admin unless they absolutely need to, and if they do, that needs to be in written policy as to why they have full admin access. Good IT practices, just in general. You want to make sure your PCs have good antivirus, security patches are on, firewalls are good. If not, you are violating HIPAA from the protection from malicious software. Not all firewalls are created equal, like we spoke of earlier. Make sure you have a good firewall configured properly. You want to use the external firewall as well as the internal firewall. Auto log off, remember, it should be, 5 minutes to 15 minutes, depending on where the system is. Auto log off in a very high traffic area should be no more than 5 minutes, but in general 15 minutes. And all staff should be told to manually lock the machine when they leave the workstation. Physical security. What are you doing to physically secure the building? Is the server in a locked room? Is the paper-based information secured? Where do you keep on-site backups? Are they secured after hours? Do you have an alarm system? Teleworkers. This is a high risk. What about folks working from home? You need to have a policy in place for teleworkers. Training is essential. Make sure very short log off policy. No one is allowed on that machine but the user. I would recommend having your IT folks configure the machine. Never store private health information on those machines. It would be better if they were only conduits to access the server at the practice or the web-based system, the web-based practice management system, and make sure all sign off on a policy that they won't be working around other members, no other family members can get on the machine, so on and so forth. Very good antivirus. There's a lot of problems that can occur with this. Wireless networking. This really isn't a problem anymore, but make sure your wireless network is encrypted, and any wireless network that's using a guest, that you're using a guest wireless, make sure that is on a segregated network, never on the same network that your private health information resides. So a little bit more low-hanging fruit real quick here. Password sharing, too many admin passwords. These are all review. Passwords not complex or changed often. Bad backup policies. No auto log off or screensaver. Non-encrypted email or texting. Bad business associates. Server not in a secured area. Paper-based PHI not in a secured area. No TV or ambient noise. No window at check-in. Staff ignorance in an interview with OCR. Web-based services utilized are not encrypted. Mannerisms of staff. Voice level of staff. Talking about PHI before entering an exam room. Lack of adequate paperwork, meaning authorization forms, business associate agreements, notice of privacy practices, are they up to date? Lack of an alarm system if deemed reasonable. Lack of system auditing. External media not encrypted. Outsourced access. How do your partners get into your system? How do you guys get into your system remotely? Is it secured? Historical records. Minimum necessary standard. Are you using that? Where are the historical records kept? Data not encrypted at rest. Antivirus not installed or not robust. Don't go cheap here. External firewalls not adequately configured or non-enterprise level. I would recommend external penetration tests. That's what I do, meaning emulating a hacker. Lack of risk assessments done. Lack of written policies consistent with procedures. A couple of just general tips, and some of these may be redundant, but I'm just trying to hammer this home. Every staff member in the office should be apprised of HIPAA standards and held accountable. Do not discuss sensitive issues with the patient while the patient is standing in the reception window and within earshot, of others in the waiting room. Not only are health-related issues confidential, this is important, but insurance and billing discussions should also be private as well. When retrieving a patient from the waiting room for their appointment, use only the first name. When providing patients with drug samples, also provide a bag for them to discreetly carry the medication through the waiting room. When placing charts for the physician, position in such a way that patient names are not visible. Use a patient sign-in system that allows the reception staff to remove or obstruct the name after sign-in. All physician offices should have a partition system so that those in the waiting area cannot hear business conducted by the staff members. When making appointment reminder phone calls to patients, exercise caution if you reach an answering machine and be certain not to leave overly detailed information in your message. Never leave a diagnosis. So, risk assessment, do it. This is bottom line, got to be done first thing. So not only required by HIPAA, but the best way to problems can be found. There's no surefire way to do this, but make sure all areas are covered. And remember, this is the first thing the feds will want to know in the event of a breach, or in the event you're being audited, or the event you're being sued and they're being brought in, is where is that risk assessment? When was it last done? In conclusion, there is no such thing as 100% security. Covered entities and business associates are just expected to follow security and privacy rule standards, implement the proper policies, procedures, and technologies, and reasonably show you guys are making an effort to protect against common threats and vulnerabilities. Real quick, business associates now get to enjoy all of the same fun and games that covered entities do, have to develop their policies, have to train their staff, have to conduct risk analysis. They're subject to federal inspections. They have to also monitor covered entities, making sure covered entities are doing the right things as well now as it relates to the contract. So make sure you have good HIPAA compliant business associates that understand this, like Big Box, those who have taken steps to ensure they're complying. Those are the business partners you want to work with. And be proactive. I've said this 1,000 times. Be proactive, not reactive. Conduct risk assessments, get policies in place, train staff, audit systems, hire good people, and always abide by the reasonable and appropriate standards here. So with that, I will open this up to questions if you guys have anything. And I know that went on a little longer than anticipated.
Okay. If anybody has questions, they can enter them into the Q&A chat box to the right of the presentation. There are a couple of questions that came in, and I'll read them out. One is, are the expectations for a small practice different than the expectations for a large practice? And just to add to that question, I mean, you've mentioned a whole bunch of times, speak to the IT department, have them do this or have them do that. A small practice might not have an IT department. So are there expectations to meet the requirements the same as a large practice or a large medical associated business?
Very good question. And the answer is yes and no. All practices, big, small, short, tall, have to all abide by the same rules and regulations, all of these implementation specifications I went through. However, with a small practice, a lot of them aren't going to apply, but we need to still put in writing why they do not apply and document that, so we're satisfying the federal government. I mean, you may not have an IT department, but you may outsource IT to an individual, and these things still need to be done if you're dealing with private health information, how it's being secured, how it's being accessed, if it's electronic versus paper, what you're doing to train staff, and all of these other things. It's just not quite as involved as if you're at the big hospital in New York City versus the small mom and pop practice down in South Georgia somewhere. But all the rules still apply and still need to be addressed. And unfortunately, it's the smaller groups that don't fare as well.
Another question that came in connected to the same topic is, would you encourage the use of web-based services such as a management service or software instead of having it on individual computers? Users will log in to a web-based platform where the data is stored and done by an outside company.
Yes, actually, yes, if it's a reputable company, definitely use that and make sure that they meet compliance with HIPAA. But there are positives and negatives. If you have it on site, it may be a little faster. You're not relying upon the internet, of course. But then again, you're opening up yourself up to a lot of headaches. You're going to have to pay IT people more. You're going to have to update that server. You're going to have to worry more about physical security, disaster recovery, and things like that. So a web-based service definitely is something I would recommend, especially for the smaller groups. The much larger groups tend to like to keep it in-house. That just depends on your how you feel about it. I mean, some folks want to have their electronic health record or their practice management system in-house, but back it up off-site, which is greatly encouraged. Some want to have everything off-site in the cloud. It just depends on your needs, your bandwidth, and several other concerns as well. But just make sure that's a good group that you're working with.
Who on staff usually deals with the HIPAA issues and making sure that everything's being done properly?
Well, you would need to, in writing, have a, quote, HIPAA security privacy official, usually in a small group, that's going to fall to the practice manager, who may delegate a lot of the responsibilities to someone more technological, may delegate some of it to HR. But in a much larger group, you're going to typically have a separate individual for HIPAA security, which is going to be more of an IT person, and then HIPAA privacy, which is going to be more of an organizational HR person who's dealing with more of the paperwork aspects of it.
Okay. The last question, at least for now, is where can I go about getting copies and drafts of the policies that you mentioned?
Of the implementation specifications, if you can get them from hhs.gov. Now, they don't have specific policies, but they'll tell you all of the implementation specifications where you can write policies. You can Google HIPAA security rule implementation specifications, and you'll pull up a lot there. I'm always happy to help out if you need help getting these things in place as well, but you can do them yourself. Just make sure and cover doing a risk assessment. If you're going to do the risk assessment yourself, use these guidelines. Google HIPAA security rule NIST, NIST, as in National Institute for Standards and Technologies. NIST, HIPAA security rule NIST risk assessment. There's also a risk assessment tool at healthit.gov. Again, that's healthit.gov, and type in risk assessment tool. And to write policies, you just read what the implementation specification says. Here's our policy. Here's the procedure on how we're going to do it. And if it does not apply to you, you still want to say does not apply because our risk assessment states, based on the way we do business, XYZ does not apply, so on and so forth. There's many reasons why it may not apply. But make sure and address that.
Okay. Do you have a lot of resources available on your own website? Tips?
You can certainly go to my website at HIPAA-consulting.com, and it links to multiple websites. There's a lot of other webinars I've done as well, but it's HIPAA-consulting.com if you want to get some more information as well from there. I believe that links to the Facebook page, which has some good information.
Okay. I'd like to encourage everybody to complete the webinar attendance form. There's a link to the form underneath the viewing screen, the video viewing screen. Please enter your information into the attendance form so we could send you the CE credits. I would like to thank you, Brian, for taking the time and giving this presentation. Very informative and helpful. And I'd like to thank everybody for taking the time to attend and view. And please go to biobigbox.com. As Brian mentioned, we have a lot of services, HIPAA compliant services connected to digital information, and we'll be rolling out a lot more features, functionality, and updates in the near future. Brian, thank you very much.
Thank you. You guys have a great day.